Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with what happens if you get a low appraisal, an appraisal that comes in lower than the contract sale price, and the buyer and seller are binding under the GAR contract package, Georgia Association of Realtors contract package. Well, like I always teach, and you've heard me say in these videos, look to the contract for the instructions regarding what has to happen. The contract is nothing more than a set of instructions regarding what has to happen in a variety of situations and circumstances. So let's go there first. So under the GAR, Georgia Association of Realtors contract package, the form that we are talking about is the conventional loan contingency exhibit, which is GAR form F404. And in that form, under paragraph 11, which is the appraisal contingency, then this is where I'm getting all this information. Now, the reason I'm doing a video on this is there's a lot of confusion regarding the time frame and termination rights for the buyer to protect their earnest money should the appraisal come in lower than the contract sale price. So there is a fill in the blank, and everybody, agents and brokers, we all talk about that as the appraisal contingency time frame. But there is so much more packaged into that within this actual exhibit that the buyer and seller agree to. So I'm not going to read this whole paragraph to you. You can read it for yourself. It's in the GAR Conventional Loan Contingency Exhibit, Georgia Association of Realtors, GAR Form F404. And it is the appraisal contingency. It's 2 paragraphs. There's one fill in the blank that has a number of days from the binding agreement date that we, like I said, generally refer to as the appraisal contingency time frame. But there's another paragraph with already pre-printed time frames in there. And that's the part I want to discuss in today's video. So in essence, what happens is you must follow the very specific procedure and timelines that are outlined in that exhibit. So in any contract, if the appraisal comes in lower than the sale price, the buyer always, without any special stipulation or anything, the buyer always has the option to go ahead and close on the transaction for the contract sale price regardless of the appraisal value. Now, the buyer's going to have to bring cash to the table for the difference, but the buyer always can do that because they went under contract with the seller for that sale price. However, usually a buyer is going to have an appraisal contingency protection so that if the appraiser comes in and doesn't appraise the property for that price, there are termination rights for the buyer where their earnest money will be protected, but you must follow the procedure. So that fill in the blank, what that part is before 11:59 p.m. on the day that is that number of days from the binding agreement date. And again, that date was negotiated. Those number of days were negotiated between the buyer and the seller when they went binding on the contract. We're seeing anywhere from 14 or 15 days to 21 days. The buyer, before 11:59 p.m. on that date, the buyer must send an amendment to the sale price to the seller. And in GAR, that is GAR, Georgia Association of Realtors Form F713, Amendment to Sale Price. And that amendment must be for a price that is equal to or more than what the appraisal value is. And the buyer must also send a copy of the appraisal. This is the only time frame in the contract that is negotiated regarding this issue. The time frame by which the buyer must send the seller an amendment to reduce the sale price and a copy of the LO appraisal. Then the seller, now the ball's in the seller's court. The seller now has until 11:59 p.m. on the 3rd calendar day from the day they received that amendment to the sale price along with a copy of the appraisal to either accept the lower sale price or reject it. However, watch your calendar because these 3 calendar days cannot be, this time frame must be at least 2 or more days away from the closing date. You can't squish this all in too close to the closing date, or the buyer doesn't have this right, this protection. So you have to take a look at all of these time frames, and it has to be done within enough time before you're scheduled to close for the buyer and the seller to work through this time frame and this procedure. So again, buyer, start from the beginning. Buyer has X number of days from the binding agreement date, if the appraisal comes in low, on GAR, conventional loan, to send to the seller an amendment to reduce the sale price to the appraisal value and a copy of the low appraisal. Then, once the seller receives that, the seller then has 3 calendar days to either accept it or reject it. If the seller accepts it, you sign it and you go to closing for that new sale price. Make sure your lender and your closing attorney get a copy of this new amendment because it has the new sale price on it. If, however, the seller rejects the amendment and rejects the lower sale price, then the buyer has an additional 3 calendar days to terminate the agreement and protect their earnest money, get their earnest money back by not meeting this contingency. However, again, you need to watch your calendar because this second 3 calendar day time frame cannot be more, it has to be at least 1 or more day away from the closing. If the buyer fails to terminate the agreement within this time frame, then the buyer must go to closing and pay the contract price that they agreed to. They'll have to bring cash for the difference. If the buyer just simply fails to show up for closing, the buyer will default on the contract and the seller would be entitled to the earnest money as liquidated damages for that default. So again, that time frame that gets negotiated, that is not a time frame for termination rights for the buyer. That is only a time frame to start the process of negotiating through this low appraisal. Couple of things to keep in mind. Watch your calendar. And this is only the instructions or the verbiage under the GAR purchase and sale agreement, the GAR conventional loan contingency exhibit. If you guys are binding under the RE forms and the buyer's getting a conventional loan contingency, the buyer's getting a conventional loan and the appraisal comes in low, it's a completely different process, and I'll do another video on that. Additionally, regardless of if it's a GAR contract or an RE forms contract, if the buyer is getting an FHA insured loan or a VA insured loan, the process is completely different there too. So there are different processes, procedures, and rights for a buyer's earnest money to be protected if the buyer was going to terminate if the appraisal comes in lower than the contract sale price. This process that I outlined is all spelled out in the GAR exhibit. And again, the actual financing contingency is GAR F404, Conventional Loan Contingency Exhibit. And the amendment that must be proposed to the seller is GAR Form F713, Amendment to the Sale Price. Whew. Hope this contract tip helped you out. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.